Welcome back, and welcome to everyone who has just arrived. So we're about to start our second panel, again on the early American context, or the American context of conscience. This one is dramatically titled MIA, Conscience and the First Amendment. And we are especially grateful to our panelists and respondents today because two of them are filling in graciously at the last minute for cancellations. The first of these is Jack Rakove. He is William Robertson Co-Professor of History and American Studies and Professor of Political Science here at Stanford. He, among his 6 books, Original Meanings, Politics and Ideas in the Making of the Constitution, received the Pulitzer Prize in History. And his recent Revolutionaries, A New History of the Invention of America, was a finalist for the George Washington Prize. His current project will be part of the Oxford University Press series on inalienable rights, and it's entitled Beyond Belief, Beyond Conscience, The Radical Significance of the Free Exercise of Religion. Our second speaker today will be Michael J. Perry, who is Robert W. Woodruff Professor of Law and Senior Fellow for the Center of the Study of Law and Religion at the Emory University School of Law. And his books include The Political Morality of Liberal Democracy, it's his most recent work, Constitutional Rights, Moral Controversy, and the Supreme Court, Toward a Theory of Human Rights, Religion, Law, Courts, and Under God, or rather, under God, there's a question mark there, religious faith and liberal democracy. And our respondent today, who has also stepped up to fill in for someone impeded by the storm. I'm sorry, to fill in for you. So it's a chain of substitutions, but is Derek Webb, who is a fellow at the Constitutional Law Center here at Stanford. So after our panelists speak, as usual, Derek will give his response, and then we'll open things up to Q&A from the audience and participants. So thank you very much, and please join me in welcoming our panel.
Well, hi, I'm Jack Rakove, and by way of introduction, I'll say this is kind of at least a singular, maybe a dual act of conscience. I mean, Nancy, I was originally supposed to be the commentator on this session. Then Nancy wrote me about a week or a week and a half ago saying that for a failure of conscience, that I could, on the part of Steve Carter, who was supposed to be the speaker, could I fill in? I got interested in this, so Carter's boss is an old friend of mine, the dean of Yale Law School, so I wrote him a note asking what gives with you guys, and to which I didn't get much of a response that I'll pass on. So that means I don't have a formal paper to present here, but I do have there's a project I've been working on and begun writing and have thought a lot about that I'd like to try to describe. It won't be a finished paper, which I just haven't had the time in the last few days to do since I spent a good part of that at James Madison's house in Montpelier. In between. But, as was said, I am working on a book called Beyond Belief, Beyond Conscience, The Radical Significance of the Free Exercise of Religion. And so what I'd like to do is to try to explain what that book is about, the arguments that I want to try to make, and I think, and then try to relate them in part to themes of conscience, though I don't pretend to be a big expert on conscience per se in the way in which it's described in the first panel, but to try to present in the context of how one thinks about the protection of rights and other ideas of constitutional government in American history more generally. The book is meant for a series that Oxford University Press is publishing called Inalienable Rights. The general editor of that is Jeff Stone from the University of Chicago. I was involved actually in the original discussions about how the series might take form. I'm actually one of only one or two historians who's contributing to it. The bulk of the contributors are law professors, including several of my colleagues here at Stanford, including Mike McConnell, who's a major expert much more of an expert on the religion clause than I could ever pretend to be. One thing about this subject is it's a kind of hit me with your best shot approach, meaning we're not meant to prepare some set of authoritative summaries of a particular area. I mean, as I was saying to Kent Greenwald, I have his 2 volumes on religion and the Constitution next to me as I work on this, through which I still have to work myself quite patiently because it's a very complex and particularistic subject when you get into the modern jurisprudence. So what's appealed to me about this, some of you may know, I'm part of my life I define myself as a Madisonian. I was just in Montpelier for a couple of nights over the weekend at Madison's house. My original point of entry actually in the subject in many ways comes from trying to make sense of Madison's distinctive concern and the importance of his attachment to notions of freedom of conscience, free exercise of religion, disestablishment during the period. And then what I'm trying to do is to work outward from that. And what I'd like to do, I don't want to say this is exactly a book talk, but in a sense it will be. I mean, it's not a book talk about a finished book, but it will be discussion of an argument about how to think about why I believe, to my way of thinking, the religion clause of the First Amendment, both the free exercise part and the disestablishment part. Congress shall make no law respecting establishment of religion or prohibiting the free exercise thereof. Why they should loom so large in our understanding of some larger constitutional themes. And I think one point of departure here is, I think particularly for Americans, because I think now, and I think indeed for some time, we take the concept of the free exercise of religions so much for granted, just so much a part of our, of our mental world and how we think about our values, that to go back and understand why at some point it was truly innovative and substantial, and how and why, and illustrate some basic aspects of some fundamental aspects of the whole American constitutional project. I think it's something that requires a little bit of a leap of the historical imagination. So that's what I'm going to try to do in this book. Let me start by, I think with I'll call it 2 points of departure, and then I'll go on and sketch my larger argument. And I should say also, Derek, I gave Derek one essay I've already published that's on the subject to read, and I sent him the outline from which I'm working. So whatever he has to say about me, I'll credit him in advance. It has to be based on a fairly minimalist approach, and in terms of what he's been able to read. So I want to start with kind of what I see as 2 basic points of departure, situated largely in the late 18th century. That's to say, I could say from 1776 to 1791, or 1776 to 1800, whatever. But 2 points situated essentially at the very end of the colonial period, the beginning of the Revolutionary era, and the founding era to which the Revolution gives rise. First off, I assume this would accord pretty well with Andrew's point from this morning. I think that by the middle of the 18th century, in the American colonies, there was a very broad and deep and principled acceptance of the principle of freedom of conscience as a natural right that simply pertained very much across the society. When I speak about conscience here, I want to say very specifically, I mean conscience primarily in terms of rights of religious belief. I don't want to reach out and deal with all the philosophical questions about what would it mean to act conscientiously in a whole array of situations. Though actually, pick up on Mark's paper, I did start to think about how one goes from the era of Robert Cain to the mid-18th century, then maybe on to the 19th century, when issues of conscience as a basis for political action will become more important. I just started thinking about that while I was listening to you talk this morning, and we can talk more about this later. So I think one fundamental point of departure is to say that by the midpoint of the 18th century, Americans really had reached a fairly advanced position on ideas of freedom of conscience, that it was not something that really had to be fought over at a deep level. I would not want to suggest that one could freely exercise religion without restraint. As a Madisonian, if you know the literature, there's a very famous, much quoted letter that Madison writes, I think it's in 1774, to his good friend William Bradford, who's living in the enlightened land of Philadelphia as opposed to Orange County, Virginia, where Madison complains about the behavior of local justices of the peace who've just rounded up and imprisoned, kind of put behind bars for a couple days, a group of Baptist preachers for preaching without a license. I mean, there are behavioral aspects, behavioral restrictions on the free exercise of religion, which still did operate in the American colonies. If you know the wonderful book by the scholar's name, Southern Cross by Christine Harriman, if you know her book on dissenting religion in the late 18th century South, she's very good on the disruptive impact that evangelical preachers, Baptists and Methodists would have on Southern society, and the ways in which they were disruptive, and they would be restrained. So I don't want to say that there's broad acceptance, fully broad acceptance of free exercise of religion without any constraint at all. But I think the idea that every man and woman, it's important to say every man and woman, could come to religious convictions as a matter of individual choice and individual searching, or the essentially Protestant search for the best means of salvation. I think that had become very much a commonplace, and I think it was perceived as a natural right. Why this was the case, I don't think is all that problematic by this point. Much of it, I think, just comes out of the inherent, the radical Protestantism, or the nature of the pervasive presence of a kind of radical Protestantism throughout America. The idea that the essence of religious experience was about coming to the right conclusions about true saving faith and a sufficient body of argument and disputation taking place among the various denominations as to exactly what the basis for that would be. Some of that goes back, of course, to the early 17th century origins. Some of it's complicated and reinforced by the experience of the Great Awakening in the 1740s. Whether or not the Great Awakening really did take place, a subject historians seem to still dispute, but there's a lot of evidence with an Edwards scholar sitting here that there's a fair amount of activity that would qualify under that. So we have a kind of legacy of radical Protestantism. I think there's certainly an acceptance of Lockean principles, broadly defined among the enlightened, and I would include Franklin probably early on as this. Tim Breen made this point at some length in his first book about political arguments in early 18th century America. So kind of a broad acceptance among the enlightened of Lockean principles. And I think finally the weakness of established religion, whose weaknesses are exposed even more by the experience of the Great Awakening. It's very difficult to enforce orthodoxy in the American colonies when established churches, where they are legally established, are already so weak. I think one way to think about this is, and I wonder what Kent thinks about this, so maybe he'll tell us later, but it seems to me that in a lot of ways Americans have moved towards a kind of non-preferentialist form of multiple establishment by the eve of the Revolution. That if they looked at our debates about what non-preferential establishment religion might mean, it wouldn't be very hard for them to do it. That's essentially what Patrick Henry, I think, was proposing or supporting in the mid-1780s. And the famous episode in Virginia where there's a bill, an assessment bill for to pay all teachers, all ministers of Christianity. So established religion survives, but in a form that by European standards would appear to me to be fairly weak. So that's my first point of departure. I just want to qualify it in terms of how I want to do this book, because I think it's a noteworthy point. Next quarter here I teach a class called Heretics to Headscarves, which is basically an attempt to look at half a millennium of ideas about religious toleration. And it does seem to be one interesting way to think about the American situation would be to juxtapose it with what we know about what's going on in Europe in the 16th and 17th century, where there has been a recent body of writing. There's a wonderful book by a guy named Benjamin Kaplan, Divided by Faith, and a book by an English historian, Alexandra Walsham, with the wonderful title Charitable Hatred, which is the best way to characterize religious toleration, meaning having to accept something you profoundly detest. I mean, the true proper meaning of toleration. It's not the kind of middle of the road feel good notion that we have. Yeah, of course we live in a tolerant society, and if you ever look at, I think about the other night watching the Romney Party and the Romney lack of a party and the Obama Party in my native town of Chicago. Gives you a good sense of what living in a toleration society, might fully mean. For us, toleration, I think we take as a matter of course, but in the 16th, 17th century, to move towards a situation of toleration means you have to accept something you fundamentally detest because the costs of repressing it have grown too high or too painful. So I think actually trying to think about what it is that situates Americans or distinguishes Americans from their European antecedents, even when European ideas, let's say Calvinist ideas, about the continued legitimacy of using coercion against dissidents. I think that's an interesting question that Americans probably have not thought that much about. So just a point I want to throw out there. So my first point of departure, I agree, very much that this is a broadly tolerationist or moving towards a free exercise notion by the eve of the Revolution. Secondly, because of my particular interest, I do think it is worth noting the consciousness, not just a sense of conscience, but the consciousness with which after 1776, various American groups do think much more explicitly and deliberately about what perfecting a position on the religion question that will go beyond toleration would mean. My favorite passage here, which I come back to repeatedly in writings and certainly when I teach this to my students, is a passage from Jefferson. So Jefferson first meets my alter ego, James Madison, in the fall of 1776, when they were both members of the Committee on Religion in the Virginia Assembly. That committee was working on in fact, responding to the revised version of the religion article in the Virginia Declaration of Rights that Madison had been responsible for drafting or amending back in the spring of 1776, which moved from toleration towards a free exercise position. The original version said, we'll tolerate, and Madison says that's not enough. It's, the right to believe is, I'm just paraphrasing here, simply belongs to us as citizens. One upshot of this is the Virginia Assembly starts getting petitions from dissenting groups within Virginia saying they should go the whole course and officially disestablish in Virginia, meaning that the Church of England, later the Episcopalian Church, would just be another denomination. So that's when Jefferson and Madison first meet. The great part of this is we have Jefferson's reading notes from this period in Williamsburg. Jefferson saying in his college professor George Wist's house. And so Jefferson goes back to actually does go back to Shaftesbury, and he goes back to Locke. And when he's reading Locke on toleration, he says, it was good to go so far, as Locke himself says of the Parliament, which passed the Act of Toleration. But where he stopped, we can go on. And I think that phrase, where he stopped, we can go on, has a kind of, does have a profound meaning in sense of it's going beyond. Locke, of course, in the 18th century means going beyond, just as with Madison in the spring, it means going beyond the concept of toleration. It means, Locke's famous exceptions for toleration were, of course, Catholics, atheists, and those who don't accept the principle of toleration itself. Jefferson and Madison, I think, were already thinking in much more expansive notion. So I think this notion of moving beyond toleration towards or also really beyond just accepting free conscience, freedom of conscience, the realm of interior belief, was, at least for these guys, a major part of the original project. So that's where I start, and what I do now, is to try to go on and talk a little bit more specifically about why I think the acceptance of both, freedom of conscience and free exercise were so consequential in ways that we do not fully appreciate. Basically, I think I have about 5 points that I'd like to make here in order. And again, I apologize if this is a little too spontaneous, but as I say, I didn't have time to write anything out, so it's the best I can do. So I want to start with a question, which I think is, again, something Americans can easily be rather superficial when we think about. I want to start by asking, what is the proper definition of a right? When we talk about rights, if I mentioned Madison trying to revise the religion article in the Virginia Declaration of Rights for May 1776, what is the proper definition of a right, and where would freedom of conscience or free exercise enter into our understanding of rights? And again, the argument I want to make here is that there's a radical aspect, there's a super powerful aspect to the significance of the religion question, which again, because we take it so much for granted, we can readily overlook. So I think when Americans think about rights, we start with the opening language of the First Amendment, where the religion clauses are the religion clause is the first part, Congress shall make no law. And the no law notion implies, just that's, and as Justice Black was famous for saying, no law means no law. It's an absolutist kind of statement in terms of authority. I think in a kind of common sense way, or in a kind of customary way, when we think no law, what we really think is government is actually being denied the capacity to act. Congress will make no law, by extension under Section 1 of the 14th Amendment. The states can't do so either. I think that's a great misconception about what it really means to have a right. If we spend any significant amount of time looking at rights, or looking at the whole corpus of the first 8 amendments and the 14th Amendment, what we need to understand about rights, first and foremost, is it's not about exempting us from public scrutiny or public supervision. It's not about creating us as fully autonomous individuals detached from a community. Basically, what most notions of rights means, it seems to me operationally, is that government is going to act towards us in some way, but when it does act, it has to conform to some fixed set of standards or which could be specified as procedures, to which it has to adhere. If you think about unreasonable versus reasonable search and seizure, or just think about the whole context, that whole catch-all phrase, due process of law. Essentially what this means is when we have a right, we're not exempted from supervision by the public. What it means is when the state acts vis-a-vis our lives in whatever capacity, we want to know what are the standards to which public authority has to conform. That's what most rights actually mean. That's why I think the concept of due process, however expansive it's become over time, really is in some ways the best way to summarize this. Now, if you start with that conception, that this is what rights ordinarily mean, then my second point becomes something more like this. So let us think about the nature of either freedom of conscience or free exercise. What that essentially says is we're going to identify a realm of behavior, let's say a realm of belief and behavior, into which the authority of the state cannot intrude at all. Well, it may intrude when we act. I'll have to qualify that. If you're Jehovah's Witnesses in like one of the leading cases from the late 1930s, 1940s, Cantwell versus Connecticut, or Chaplinsky versus whoever Chaplinsky was opposed to, there are outward forms of manifesting behavior for which you will become accountable. But the idea that the right to believe was a matter of, I'll use this phrase somewhat awkwardly, individual sovereign autonomy, that neither the state nor the church after this point would have any capacity, any power to affect your belief. That, it seems to me, is a very powerful conception which sets freedom of religion beyond what we would expect to find in other realms of behavior. And so, in my view, what makes freedom of conscience so significant is it seems to me to identify the one realm of rights, the one realm of our behavior, the one realm of our essential activity, where in fact we have a capacity that lies beyond the power of the state to affect. I think for the Americans, go back to what I said at the very beginning, for the Americans who have reached that position by the, at least latently, by the midpoint of the 18th century or a quarter century later, by the end of the revolution, it seems to me, again, in a European comparison, that's still a very powerful position. That's a pretty strong, pretty impressive destination to have been able to attain. After all, if you think about the whole history of Europe, where people have been slaughtered, or one could say, I suppose more broadly, the whole history of Christianity, where people have been slaughtering each other with gay abandon over the centuries, over matters of religious belief, to say that, no, actually, here's a realm of behavior where the state is going to begin to abjure its authority, and where private churches will not be able to act either, obviously. It seems to me that's a fairly significant point of view. And it's also the point I want to develop out of this, it is the one, I think this picks up on something said in the previous session, it's the one I think that comes closest to identifying individual members of society as subjective free actors. It's the most liberal. I'm a little nervous about using the term liberalism, whether you ascribe it to Locke or anyone after. I mean, maybe until you get to Mill. I'm not sure exactly when the right moment to say liberalism really emerges is. But it does seem to me, in the sense in which we ordinarily use that term, the right to freedom of conscience, the right to decide what you want to believe or not to believe in the realm of behavior, strikes me in many ways as being the most liberal, the most individualistic, the most subjectivistic of all the rights that we can possess. That, it seems to me, is a fairly radical statement. It's the one that describes the greatest autonomy to individuals, to be capable of making choices in an area where traditional society would have said, we want to be very careful, very prudent about the choices that we allow people to make. Why? Because if you allow people to make up their mind about, religious matters, who knows where the mischief will end? Who knows, to what consequences they won't fall. And again, as I mentioned earlier, this is a right that it is, when you kind of study the sociology of congregations, not that I do this actively, but I know some of the literature, it is a right that belongs equally to men and women alike, and, not all spouses think alike on these matters, and women are arguably more devout in many cases, many congregations, than their spouses. So it does, in some ways, apply across the gender divide. So that makes it a significant point. That's my second point. Third point, try to tie this in with contemporary constitutional debates. As I'm sure many of you know, We've had a lot of laughter and good humor in American jurisprudence over the last 45, 47 years or so, ever since Griswold versus Connecticut, the famous Connecticut contraception decision where Justice Douglas, for reasons good or bad, who knows, talking about the right to privacy, used the famous formula, penumbras formed by emanations established by the Bill of Rights create zones of privacy into which the authority of the state cannot intrude. I think I got there pretty close to the original text. So we like the phrase in the realm of constitutional law. What does it mean to talk about a penumbra formed by an emanation? Intellectually, it's probably not the most satisfactory, metaphor. As a New Yorker used to say, block that metaphor. It's probably not the best device to use to talk about the sources of rights. And so the idea of do we have a constitutional right to privacy ever since has been as easy to lampoon as it is to try to defend. I've often thought, though, if you really wanted to look for a source of the constitutional right to privacy, what better place could there be to look than the First Amendment? Going back exactly to what I just said, what the idea of freedom of conscience basically suggests is that here is a realm of belief and behavior where you and I, or all of us individually and collectively, are protected, against intrusion. It is wholly private in a way that other forms of activity are not wholly private. And go back to the idea of reasonable search and seizure. Your home may be your castle. And in fact, there's this whole thing, I read this from Bruce Mann's book, Republic of Debtors. Bruce Mann, you may or may not know, is the husband of the new Senator, Elizabeth Warren, very distinguished legal historian in my field. And he has an interesting discussion of the circumstances under which you can, your ability to protect, if you never want to leave your house, a warrant cannot, and nobody opens the door, a warrant cannot be served on you in the 18th century. On Sunday, you can go out, because warrants can't be served on Sunday. Although sometimes people get kidnapped on Sunday and held over to Monday. So in fact, warrants can't be served. But the basic point here is the sheriff can always give, there are some protections. But I think the idea of privacy in a more robust sense, putting the warrant exception aside, the idea that here's a realm of behavior, again, that's insulated from regulation seems to me to be a very powerful idea. And it is a conception of privacy. That's my third point. My fourth point, I think, has to do with trying to think about the relationship, and I should be close to finishing up here in about 3 or 4 minutes. I hope I'm okay on the time side. Fourth point that I want to develop here is that it seems to me that if one thinks historically about notions of freedom of speech or freedom of expression more broadly, that in interesting ways, curious ways, I think the acceptance of a open market of discourse in the realm of religion antedates, precedes the acceptance of a free market for political discourse in the realm of politics more generally. Or to put this point another way, I think blasphemy becomes problematic before seditious libel does. That's to say, it's okay to be, I don't know if you want to identify yourself as a Socinian. I'm proud of this. I don't have many connections to Socinians, except it turns out there is something called the Rakovian Catechism. Because there's a town called Rakove, somewhere in Poland, I guess. And, there's some key Socinian text which is called the Rakovian Catechism. It's no relationship to us, but I'm still delighted, by this fact. But it does seem to me that, that notions that might be regarded as potentially blasphemous do become less actionable in the realm of law by the 18th century than is true in the realm of politics. Seditious libel is still a serious issue, both in Britain and America. In America, of course, that's true down through the Sedition Act of 1798, which in many ways is a reform act, but still preserves the concept of seditious libel. It seems to be Jefferson's notion that, the more speech we have, the better off we'll be. I think in some ways develops first or, reflects the idea that perhaps open discourse in religion will be easier, more acceptable than a wholly open discourse in politics. Or if Jefferson brings the two together, he shows a fusion. But again, I think it kind of, at least I want to speculate that an openness in religious discussion in some ways antedates an openness in political discussion. There are still constraints on political discussion that 18th century, early 19th century lawyers still have to take seriously. And then finally, to bring in the other member of the religion clause, and this is actually in the series of books Mike McConnell is supposed to write on the establishment clause while I do free exercise. But I think the last point to be made here goes to the basic idea of limited government itself. What do I mean by this? I think the idea that the power government exercises, I mean, what is the great idea that comes out of the American doctrine of constitutionalism in the 18th century? It is that the government exercises only those powers that we delegate to it. But if you ask, is there any limit to those powers? How do you limit the authority of government? If you start with the orthodox 18th century British understanding, kind of embedded, let's say, in the kind of post-1688, post-Glorious Revolution notion, there's no limitation on the authority of Parliament. There is no subject matter of law that the authority of Parliament cannot reach. There is no area of human behavior that's beyond the authority of Parliament to regulate. That doctrine is essentially transferred to American ideas of state constitutionalism in 1776. When we speak about legislative supremacy in the American case, we're essentially making the same argument. To say what you do with disestablishment, or the idea of Congress to make no law respecting established religion, when you say we're pulling out of the religion field, this is a field we're abandoning. Again, given its significance in maintaining stability in every other society, particularly within the Western tradition that one would want to know about, to say we're getting out of the religion business. That's going to be a marketplace. And not only will it be a marketplace, that's going to be an unregulated marketplace, where just whatever people say, however the consumers, the auditors respond, it's going to be a wholly private realm. We're pulling out here, for all intents and purposes. Now, that of course that oversimplifies what's actually a more complicated situation. There is a body of writing about 19th century America with Sahat's book and Stephen Green. So I'm oversimplifying what's actually a more complicated story. But I do think the late 18th century understanding was moving in that direction. Indeed, what makes America a more Protestant society in the 19th century than in the 18th century is that having the government pull out of the religion business, opening up that marketplace, makes Americans more evangelical in the 19th century than they'd been before. And then once they become evangelical, they try to put more pressure to bear on the public to act in conformity with religious principles. So it's a more complicated story. But I think if you go back to a core constitutional principle, the striking thing here is to see that disestablishment is not just significant in itself as a way of solving the religion problem, it best illustrates a doctrine of what it means to have limited government. To say, here's this whole realm of behavior. No society would ever have abandoned its regulation because it's so important, so dangerous. We're going to pull out. We're going to let it alone. So that's why I think, talking about the religion question is a way that it has a radical significance, which precisely because on the whole, I think the system has worked so well, we tend to forget how complicated and interesting its origins were. Thanks very much.
I am delighted to be a part of this conference. Nancy, thank you so much for the invitation. My presentation this morning, this paper, is drawn from my new book, which will be published in about a year. I'm just putting the finishing touches on it. The title of the book is Human Rights in the Constitutional Law of the United States. This part of the book, as I'll explain, is an elaboration of a particular right. And in the two following chapters of the book, one dealing with the same-sex marriage controversy, one with the abortion controversy, I pursue the implications both of this right that I'm going to discuss with you this morning and of another right I discuss in the book, which I call the right to moral equality. So, but this stands alone of interest, I think, in relevance to this conference. A right to freedom of conscience, a right that is most accurately called the right to religious and moral freedom, is internationally recognized as a human right. In this paper, I will elaborate the right, a version of which I will explain has emerged, albeit under a different name, in the constitutional law of the United States. Jocelyn McClure and Charles Taylor began their recent book, Secularism and Freedom of Conscience, by stating that, quote, one of the most important challenges facing contemporary societies is how to manage moral and religious diversity. As I am about to explain, establishing and protecting the right to religious and moral freedom, McClure and Taylor prefer the term freedom of conscience, is one of the most important ways for a society to manage moral and religious diversity. The articulation of the right to religious and moral freedom that we find in the International Covenant on Civil and Political Rights is canonical in this sense. Over 85% of the countries of the world, including, as of 1992, the United States, are parties to the International Covenant. Now, I think it's important that I put Article 18 in front of you, and it states as follows: everyone shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice, and freedom either individually or in community with others, and in public or private, to manifest his religion or belief in worship, observance, practice, and teaching. That's paragraph 1. 2, no one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. 3, freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. And then finally, the fourth part of this Article 18 of the International Covenant, the state parties to the present covenant undertake to have respect for the liberty of parents and, when applicable, legal guardians to ensure the religious and moral education of their children in conformity with their own convictions. The United Nations Human Rights Committee, the body that monitors compliance with the International Covenant, and under the first optional protocol to the covenant adjudicates cases brought by individuals alleging that a state party is in violation of the covenant. The UN Human Rights Committee has stated that, quote, the right to freedom of thought, conscience, and religion in Article 18 is far-reaching and profound. How far-reaching and profound? Note the breadth of the right that, according to Article 18, everyone shall have. The right to freedom not just of religion, but also of conscience. The right shall include freedom to have or adopt a religion or belief of his choice, and freedom either individually or in community with others and in public or private to manifest his religion or belief in worship, observance, practice, and teaching. Article 18 explicitly indicates that the right concerns moral as well as religious freedom. Article 18 explicitly identifies the belief that is protected as moral belief when it states that the state parties to the present covenant undertake to have respect for the liberty of parents and, when applicable, legal guardians to ensure the religious and moral education of their children in conformity with their own convictions. So the right we're now considering protects not only freedom to practice one's religion, including, of course, one's religiously based morality, it also protects freedom to practice one's morality, freedom to, quote, manifest his belief in practice, even if one's morality is not embedded in a religious tradition, even if, that is, one's morality is embedded not in a transcendent worldview, but in a worldview that is not transcendent. And by transcendent worldview, I mean a worldview that affirms rather than denies or is agnostic about the existence of a transcendent reality as distinct from the reality that is or could be the object of natural scientific inquiry. As the Human Rights Committee has put the point, the committee draws the attention of states parties to the fact that the freedom of thought and the freedom of conscience are protected equally with the freedom of religion and belief. Article 18 protects theistic, non-theistic, and atheistic beliefs, as well as the right not to profess any religion or belief. The terms belief and religion are to be broadly construed. Article 18 is not limited in its application to traditional religions or to religions and beliefs with institutional characteristics or practices analogous to those of traditional religions, said the Human Rights Committee. In deriving a right to conscientious objection from Article 18, the Human Rights Committee explained that, quote, the legal obligation to use lethal force may seriously conflict with the freedom of conscience and the right to manifest one's religion or belief, and emphasized that, quote, there shall be no differentiation among conscientious objectors on the basis of the nature of their particular beliefs. So given the breadth of the right we're now considering, the far-reaching and profound right of which the International Covenant's Article 18 is the canonical formulation, the right is accurately described not as the right to religious freedom, but as the right to religious and moral freedom. The Canadian Supreme Court has emphasized that the right to religious and moral freedom is a broad right that protects freedom to practice one's morality without regard to whether one's morality is religiously based. Referring to Section 2A of the Canadian Charter of Rights and Freedoms, which states that everyone has freedom of conscience and religion, the Canadian Supreme Court explained, the purpose of Section 2A is to ensure that society does not interfere with profoundly personal beliefs that govern one's perception of oneself, humankind, nature, and in some cases, a higher or different order of being. These beliefs, in turn, govern one's conduct and practices, said the court. According to the Canadian Supreme Court, Section 2A, quote, means that subject to certain limitations, no one is to be forced to act in a way contrary to his beliefs or his conscience. Religious and moral freedom, as the Canadian Supreme Court explained, is the freedom to live one's life in accord with one's religious and or moral convictions and commitments. Specifically, those that are the yield of one's response to what are sometimes called ultimate questions, such as, who are we? Where did we come from? What is our origin, our beginning? Where are we going? What is our destiny, our end? What is the meaning of suffering, of evil, of death? And there is the cardinal such question, the question that comprises many of the others: is human life ultimately meaningful, or instead ultimately bereft of meaning, meaning less absurd? If any questions are fundamental, these questions, what Catholic theologian David Tracy has memorably called religious or limit questions, are fundamental. Such questions, questions that the narrator in Milan Kundera's The Unbearable Lightness of Being called naive questions, questions with no answers, barriers that cannot be breached, are, said Tracy, the most serious and difficult that any human being or society must face. Historically extended communities, traditions, are principal matrices of answers to all such religious or limit questions. Now, consider Bertrand Russell's worldview. I quote it: that man is the product of causes which had no prevision of the end they were achieving, that his origin, his growth, his hopes and fears, his loves and his beliefs are but the outcome of accidental collocations of atoms, that no fire, no heroism, no intensity of thought and feeling can preserve an individual life beyond the grave, that all the labors of the ages, all the devotion, all the inspiration, all the noonday brightness of human genius are destined to extinction in the vast death of the solar system, and that the whole temple of man's achievement must inevitably be buried beneath the debris of a universe in ruins. All these things, if not quite beyond dispute, are yet so certain that no philosophy which rejects them can hope to stand. Only within the scaffolding of these truths, only on the firm foundation of unyielding despair can the soul's habitation henceforth be safely built. Russell's statement, and many others like it, are useful reminders and powerful illustrations that those who struggle with religious or limit questions do not invariably end up giving answers that constitute a transcendent worldview. To the contrary, many end up giving answers that constitute a thoroughgoing rejection of any transcendent worldview. Nonetheless, as John Paul II was surely right, and John Paul II was surely right in his encyclical Fides et Ratio, that such questions, quote, have their common source in the quest for meaning which has always compelled the human heart, and that the answer given to these questions decides the direction which people seek to give to their lives. The breadth of the right we're now considering reflects what Catholic philosopher Charles Taylor and his co-author Joyce McClure have emphasized in their recent book. Namely, the democratic state must treat equally citizens who act on religious beliefs and those who do not. It must, in other words, be neutral in relation to the different worldviews and conceptions of the good, secular, spiritual, and religious with which citizens identify. Religious diversity must be seen as an aspect of the phenomenon of moral pluralism with which contemporary democracies have come to terms. Although the history of the West serves to explain the fixation on religion, the state of contemporary societies requires that we move beyond that fixation and consider how to manage fairly the moral diversity that now characterizes them. The field of application for secular governance has broadened to include all moral, spiritual, and religious options. Now, two clarifications are in order. The practices protected by the right to religious and moral freedom include not just practices one believes oneself religiously and or morally obligated to engage in. After all, a practice one believes oneself obligated to engage in may be relatively inconsequential next to a practice one does not believe oneself obligated to engage in, but that nonetheless one has strong religious or moral reason to engage in. Second clarification, the practices protected by the right to religious and moral freedom include those that are animated by what McClure and Taylor call a person's core or meaning-given beliefs and commitments, as distinct from those that are animated by the legitimate, quote, the legitimate but less fundamental preferences we display as individuals. And they have a very interesting elaboration of that difficult distinction, which I'll pass over. Some international covenant rights, such as the Article 7 right not to be subjected to torture or to cruel, inhuman, or degrading treatment or punishment, some rights are unconditional, absolute. They forbid or require government to do something, period. Some other covenant rights, by contrast, are conditional. They forbid or require government to do something unless certain conditions are satisfied. As Article 18 makes clear, the right to religious and moral freedom is conditional. Under the right, government may not ban or otherwise impede a practice protected by the right unless each of three conditions is satisfied. First, the legitimacy condition. The ban or other policy must serve a legitimate government objective. Secondly, the least burdensome alternative condition. The policy must be necessary to serve the legitimate government objective in the sense that the policy serves the objective significantly better than would any less burdensome to the protected practice policy. And third and finally, the proportionality condition. The good the policy achieves must be sufficiently weighty to warrant the burden the policy imposes on those who want to act in a way the policy bans or otherwise impedes. The relationship between the normative ground of human rights, which I discuss at length elsewhere in my book, namely the imperative, articulated in Article 1 of the Universal Declaration of Human Rights, to act towards one another in a spirit of brotherhood, and a right I consider elsewhere in my book is clear. To subject a human being to cruel, inhuman, or degrading punishment is obviously not to treat him in a spirit of brotherhood. The relationship between the normative ground of human rights and another right I consider in my book is also clear. The right to moral equality is the right to be treated in accord with the in a spirit of brotherhood imperative. What is the relationship between the normative ground of human rights and the right we are now considering? Why should we think that government, if it is to act towards its citizens and all other human beings with whom it deals in a spirit of brotherhood, must respect and protect the right to religious and moral freedom? To prevent someone from living his life in accord with his religious and our moral convictions and commitments, or to make it significantly more difficult for him to do so, is hurtful to him, sometimes greatly hurtful. As two Israeli legal scholars explain, quote, coercing people to act against their deepest normative beliefs presents a severe threat to their integrity and makes them experience strong feelings of self-alienation and loss of identity. Therefore, it should be avoided as far as possible. Philosopher Mark Wickler puts the point similarly in his important book in my judgment, titled Conscientious Objection in Healthcare and Ethical Analysis. Wickler states, even one instance of acting against one's conscience, an act of self-betrayal, can be devastating and unbearable. And Wickler very nicely elaborates that point. I'll pass over that. The countries of the world, the great majority of them, agree that for a government to cause anyone such hurt is for the government to fail to act towards him in a spirit of brotherhood, unless the law or other policy that is the source of the hurt satisfies each of the three conditions: legitimacy, least burdensome alternative, and proportionality. Again, the right to religious moral freedom is not, as a practical matter, it cannot be unconditional. Let us now address a fundamental question concerning the legitimacy condition. What government objectives are not legitimate under the right to religious and moral freedom? Article 18 does not call into question the legitimacy of governments acting to protect, to list the most obvious examples, the lives, health, safety, liberty, property, and socioeconomic well-being of the citizenry and other human beings, the legitimacy of its acting to protect human rights, the orderly functioning of society, including the orderly functioning of democratic and judicial processes, non-human animals, and the environment. Article 18 explicitly contemplates governments acting to protect even public morals. However, as the Syracuse Principles, United Nations document, on the limitation and derogation provisions of the International Covenant state, the scope of a limitation referred to in the covenant shall not be interpreted so as to jeopardize the essence of the right concerned. All limitation clauses shall be interpreted strictly and in favor of the rights at issue. All limitations shall be interpreted in the light and context of the particular right concerned. So, with respect to public morals, the Human Rights Committee has emphasized, quote, the concept of morals derives from many social, philosophical, and religious traditions. Consequently, limitations on the freedom to manifest a religion or belief for the purpose of protecting morals must be based on principles not deriving exclusively from a single tradition. If a set of beliefs is treated as official ideology in constitutions, statutes, proclamations of ruling parties, etc., or in actual practice, this shall not result in any impairment of the freedoms under Article 18 or any other rights recognized under the covenant, nor in any discrimination against persons who do not accept the official ideology or who oppose it. And as the editors of a case book on the International Covenant have put the point in summarizing several statements of the Human Rights Committee concerning protection of public morals under the right to religious and moral freedom, quote, public morals measures should reflect a pluralistic view of society rather than a single religious culture. It follows then that protecting public morals is not necessarily an illegitimate government objective under the right to religious and moral freedom. Whether protecting public morals is an illegitimate government objective depends. If the government objective that animates a ban or other policy involves the claim that the conduct at which the ban is aimed is immoral, the government objective is illegitimate under the right to religious and moral freedom if government's pursuit of the objective is based on in the sense that government would not be pursuing the objective but for, a sectarian belief, religious or moral, such as this conduct is contrary to the will of God. So the legitimacy condition leaves no room for the political powers that be to ban or otherwise regulate conduct on the basis of a sectarian religious or moral belief, whether that belief be, for example, that one who embraces Christianity has a much better chance of being saved, or that religion is unscientific, superstitious, and an enemy of progress. Sectarian religious belief is redundant in the sense that no religious belief is not sectarian, although some religious beliefs are much more sectarian and some much more ecumenical than others. Sectarian moral belief, however, is not redundant. Some moral beliefs are sectarian, some are not. There can be disagreement, of course, about where to draw the line, but some moral beliefs are undeniably sectarian and some are not. That all governments should treat their citizens and others with whom they deal in a spirit of brotherhood, the normative ground of human rights, is a prime example of a moral belief that was once sectarian but is no longer. As I emphasize in the book from which this paper is drawn, the morality of human rights, at the base of which is the normative ground of human rights, is a truly global political morality. That all government should establish and respect the right to religious and moral freedom is another example of a moral belief that is no longer sectarian. At the other extreme, that no one should masturbate is an example of a moral belief that is now undeniably sectarian. As McClure and Taylor put the point, certain norms, including both popular sovereignty and basic human rights, are, I quote them, the constitutive values of liberal and democratic political systems. They provide these systems with their foundation and aims. Although these values are not neutral, they are legitimate because it is they that allow citizens espousing very different conceptions of the good to live together in peace. They allow individuals to be sovereign in their choices of conscience and to define their own life plan while respecting others' right to do the same. That is why people with very diverse religious, metaphysical, and secular convictions can share and affirm these constitutive values. They often arrive at them by very different paths, but they come together to defend them. Why deny to the political powers that be, under the right to religious and moral freedom, especially under the legitimacy condition, the authority to regulate conduct on the basis of a sectarian, religious, or moral belief? Beliefs of many other sorts, beliefs about economic issues, say, or about issues concerning war and peace, can be sectarian too. And we do not deny to the political powers that be the authority to regulate conduct on the basis of those beliefs. There are two main answers, two main ecumenical answers, that is, answers that do not require acceptance or rejection of any proposition of religious faith. The first of the two answers concerns competence, or more accurately, incompetence. Recall Locke's judgment, amply confirmed by historical experience, that, quote, neither the right nor the art of ruling does necessarily carry along with it the certain knowledge of other things, and least of all of true religion. To Locke's does necessarily carry, we may add, or has ever carried. Locke, again, the only The one only narrow way which leads to heaven, said Locke, is not better known to the magistrate than to private persons, and therefore I cannot safely take him as my guide, who may probably be as ignorant of the way as myself, and who certainly is less concerned for my salvation than I am. The second main answer is independent of the first, in the sense that even if one rejected or discounted the incompetence answer, one could nonetheless accept the second. There is simply no practical need for the political powers that be to regulate conduct on the basis of sectarian, religious, or moral belief. Historical experience amply confirms that there is little, if anything, of practical import to be gained, least of all in a religiously and morally pluralistic society, by regulating conduct on the basis of such belief. To the contrary, there is an urgent need for the political powers that be not to regulate conduct on the basis of sectarian, religious, or moral belief. Again, to prevent someone from living his life in accord with his religious and or moral convictions and commitments, or to make it significantly more difficult for him to do so, is hurtful to him, sometimes greatly hurtful. Moreover, the hurtful imposition of a sectarian, religious, or moral belief is likely to be profoundly divisive in a religiously and morally pluralistic society. A society that takes seriously the right to religious and moral freedom understands not only, in the words of McClure and Taylor, that its unity does not lie in unanimity about the meaning and goals of existence, but also that any efforts in the direction of such a uniformization would have devastating consequences for social peace. So it's fitting that the great majority of the countries of the world have converged on the right to religious and moral freedom, under which, according to the legitimacy condition, government may not regulate conduct on the basis of sectarian, religious, or moral belief. It is fitting more broadly that the great majority of the countries of the world, in recognizing the right to religious and moral freedom as a human right, agree that for a government to prevent someone from living his life in accord with his religious and or moral convictions and commitments, or to make it significantly more difficult for him to do so, is for government to fail to act consistently with the normative ground of human rights. It is for the government to fail to act towards him in a spirit of brotherhood, unless the law or other policy that is the source of the hurt satisfies all three conditions, not just the legitimacy condition, but also the least burdensome alternative and proportionality conditions. As it happens, a version of the right to religious and moral freedom, a version that the Supreme Court of the United States has sometimes called the right of privacy, has been protected by the court as a constitutional right for almost 50 years. I think Jack, was it you, Jack, who referred to Griswold versus Connecticut? So in this part of my presentation, I say consider the following rulings by the Supreme Court in the period since the mid-1960s. I, in the interest of time, will spare you what I was going to do. I was going to quote for you from several Supreme Court rulings over this period of time in which their discourse is remarkably similar to the discourse of the Canadian Supreme Court under the right to freedom of religion and conscience. The discourse of the court in many of these right of privacy cases makes it sound really remarkably as if they are proceeding under the right to religious and moral freedom as I've elaborated it to you in this paper. So I'll pass over those passages and conclude with this. The Supreme Court sought to justify its rulings in those cases involving contraception, abortion, marriage, sodomy legislation. The Supreme Court sought to justify its rulings in the foregoing cases on the basis of the right to privacy and or the right not to have government deprive one of liberty without due process of law. As a matter of defensible constitutional interpretation, the court would have been on much more solid ground, much less controversial ground, had it sought to justify its rulings on the basis of the right correctly interpreted, not to have government prohibit one from engaging in the free exercise of religion. It is a bedrock feature of the constitutional law of the United States that neither the federal government nor state government may, in the words of the First Amendment, prohibit the free exercise of religion. As interpreted by a majority of the justices now sitting on the Supreme Court of the United States, the right to the free exercise of religion is not the same as, it is not congruent with, the internationally recognized human right to religious and moral freedom. There's no time here for me to explicate the free exercise right as interpreted by a majority of the sitting justices. For present purposes, it'll suffice to say that in my judgment, those religious liberty scholars are persuasive who contend, as distinguished religious liberty scholars Douglas Laycock and Michael McConnell contend, that the present court's interpretation of the free exercise right is too narrow, and that the better interpretation of the right is one according to which the right protects, conditionally, not unconditionally, this comprehensive religious freedom. Freedom to practice and otherwise live one's life in accord with one's own religion, freedom from laws and other public policies that coerce one to practice or otherwise live one's life in accord with a religion not one's own, and freedom from laws that discriminate against one on the ground that one does not practice or otherwise live one's life in accord with a particular religion or group of religions. I noted earlier in this paper that those who struggle with religious or limit questions do not invariably end up giving answers that constitute a theistic or otherwise transcendent worldview. As I said, many end up giving answers that constitute a thoroughgoing rejection of any transcendent worldview. Nonetheless, again, as John Paul wrote in his encyclical, such questions have their common source in the quest for meaning which has always compelled the human heart, and that the answer given to these questions decides the direction which people seek to give to their lives. What sense does it make, then, to interpret religion in the free exercise right so narrowly? Why think that the enactors of the free exercise provision understood religion so narrowly, even if the particular instances of religion with which they, most of them, were familiar and on which they were focused were theistic, that the provision ends up protecting only conduct embedded in a theistic worldview? Is Buddhism, which is in the main non-theistic, to be excluded from coverage under the free exercise right? And if not, if Buddhism is to be included, why not other non-theistic worldviews too? Douglas Laycock, speaking of the free exercise right, is surely correct to insist that we have to understand religion broadly so that non-believers are protected when they do things that are analogous to the exercise of religion. Non-believers have teachings about religion that the government should not establish. Non-believers speak and publish their teachings about religion. Non-believers form organizations that are entitled to autonomy and that need places to meet. Non-believers have consciences, and occasionally their deeply held conscientious beliefs conflict with government regulation. The appeal of the position for which Laycock contends, the appeal of a broad rather than miserly understanding of religion, is reflected in the breadth of Article 18 of the International Covenant. And I won't rehearse here the points I made in the early part of my paper or what the Canadian Supreme Court said. This, then, is why we are warranted in saying that the internationally recognized human right to religious and moral freedom is part of the constitutional law of the United States. The right to the free exercise of religion is part of the constitutional law of the United States, and that right, correctly interpreted, is congruent with the right to religious and moral freedom. That is, the free exercise right, correctly interpreted, protects freedom to live one's life in accord with one's own worldview, whether that worldview is theistic or non-theistic, freedom from laws and other public policies that coerce one to live one's life in accord with someone else's worldview, whether that worldview is theistic or non-theistic, and freedom from laws that discriminate against one on the ground that one does not live one's life in accord with a particular worldview or group of worldviews, whether that worldview is theistic or non-theistic. I've gone too long. Thank you.
First of all, I want to thank Nancy for the invitation to participate in this panel. This is a great honor and an exciting opportunity. And these were two very rich and interesting papers/presentations. So I have some of my work cut out for me, and then I think the audience also surely has its work cut out for it to sort of engage in a conversation with both our authors today. I want to first begin actually with Michael Perry's presentation and paper, and then work my way towards Jack Rakove's paper. The first place I want to begin with in response to Professor Perry's argument is his claim, not so much with regard to the normative argument he makes, that non-theistic comprehensive worldviews deserve equal respect and regard, but his the more focused argument that he makes with regard to whether its place in the U.S. constitutional tradition. He makes a very persuasive and interesting case and brings in documents that are helpful to us from the international context. The ICCPR, the Canadian Charter of Charter of Fundamental Rights, Charter of Rights and Freedoms, the EU Charter of Fundamental Rights. But as a matter of textual analysis, he is actually a very careful reader of these texts. He notes that it's important when those charters, whether it's the ICCPR or the Canadian Charter of Rights and Freedoms, when those texts, those constitutions, charters, use the word and or. So for instance, Article 18 of the ICCPR, which he draws upon, says, "Everyone shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice." Elsewhere, it says in that article, "No one shall be subject to coercion, which would impair his freedom to have or to adopt a religion or belief of his choice." So also in the Canadian Charter, we see everyone has the following fundamental freedoms. A, freedom of conscience and religion. Or B, freedom of thought, belief, opinion, and expression. And when those texts are cited in his paper, he draws his reader's attention to that here the authors of that text, of those charters, explicitly included an and or an or. There was religion and conscience, religion and other beliefs. I set that all up because in the context of the First Amendment, which we're discussing today, you do not see, which Professor Perry seems to think is so important, that word and or that word or. What you have in the First Amendment anyway, is Congress shall make no law respecting an establishment of religion, comma, or, you do have an or there, but, or prohibiting the free exercise thereof, but the thereof is referring back to religion. There's religion, but there isn't the use of the word conscience or belief or other systems of thought or anything sort of gesturing in that direction. For lawyers practiced in the art of using canons of construction, when a word is not put in either a constitutional text or a statute, that usually is important. The canon is called the omitted case canon, that a matter not covered is to be treated as not covered. It was covered in these charters, but seemingly on a first glance anyway, a first reading of the First Amendment, we don't see that case covered. When lawyers sort of analyze these things, they begin first with the text, and so I begin there to sort of get the ball rolling. But then typically they move on to history in terms of sort of understanding whether something is actually has been placed in the text of the Constitution. And the history with regard to the creation of that First Amendment, I think also further suggests that those who anyway put the First Amendment into the Constitution did not have in mind an idea that it would go or extend, the protection would extend beyond religion. Here's what the House of Representatives proposed as its draft of the First Amendment when they were debating this. The final House report said, and it was broader here, Congress shall make no law establishing religion or to prohibit the free exercise thereof or to infringe the rights of conscience. So there you do have the rights of conscience thrown in. The Senate took a look at this. Unfortunately, we don't have the debates in the Senate, but the Senate removed the reference to conscience and instead threw in, Congress shall make no law establishing articles of faith or a mode of worship or prohibiting the free exercise of religion. The conference committee between the House and the Senate then got together and proposed what ultimately was the First Amendment, the conscience, where conscience was missing in action. And I believe that was actually the title of this panel. Conscience actually was missing in action in at least our First Amendment, the United States First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Madison had urged the House to include the reference to conscience. But there was some debate about that. And there was one congressman who noted he had some concern, a Congressman Huntington. As he said in the debates, he hoped the amendment, the First Amendment, would be made in such a way as to secure the rights of conscience and a free exercise of the rights of religion, but not to patronize those who profess no religion at all. And so surveying the history of the construction of that amendment and the brief sort of comments about this particular question in the record, Martha Nussbaum, in her recent book on the freedom of conscience, wrote this. Under our Constitution, the United States Constitution, religion is special. The framers rejected wording that spoke in general of rights of conscience and chose wording that singled out religion for free exercise protection. There are other things to be said about the history, the historical record there, and what the liberty of conscience meant at that time, and we can perhaps get into that as well. Even if the liberty of conscience had been successfully included, there may have also been a strong historical case to be made that actually even that would not have extended beyond religion, because liberty of conscience for about 150 years or so leading up to before the creation of the First Amendment had consistently referred to liberty of conscience as meaning conscience in matters of sort of religious belief. All right, so that's historical argument. The third thing that lawyers tend to do when they sort of look at these questions is they go from text to history and then to precedent. And Professor Perry has brought before us a number of interesting cases, Griswold, Rowe, Casey, Lawrence, that suggest this very robust right to privacy, which the court has acknowledged. But when it comes to the court's statements about the First Amendment, how to interpret that, the religion clauses in the First Amendment, the precedents seem to cut in the other direction. And not just on this current court. From 1972 on, the court has been pretty consistent in saying that when it comes to the religion clauses in the First Amendment and interpreting the text of the Constitution there, it's to understand religion clauses in terms of religion, the practice of religion itself. Wisconsin versus Yoder, 1972. A way of life, however virtuous and admirable, may not be interposed as a barrier to reasonable state regulation of education if it is based on purely secular considerations. To have the protection of the religion clauses, the claim must be rooted in religious belief. 72. And the court's had a long time to sort of reject that, but every time it's considered it, it's affirmed it. Almost 10 years later, in Thomas v. Review Board, it said that only beliefs rooted in religion are protected by the Free Exercise Clause, which by its terms gives special protection to the exercise of religion. Another 10 years or so later, in Frazee versus Illinois Department of Employment Security, there is no doubt, very strong statement, there is no doubt that only beliefs rooted in religion are protected by the Free Exercise Clause. Purely secular views do not suffice. Even Justice Brennan in 1983, commenting on this development, observed that our cases, the court's cases, recognize that in one important respect, the Constitution is not neutral on the subject of religion. Under the Free Exercise Clause, religiously motivated claims of conscience may give rise to constitutional rights that other strongly held beliefs do not. That's just the positive case with regard to text, history, and precedent about what we have to work with regarding when sort of dealing with and trying to resolve this very interesting question about whether religious protection should extend to non-theistic beliefs. When it comes to theory, Professor Perry does provide, I think, a very persuasive and attractive account for, on the grounds of a sort of Dworkinian equal regard for citizens, whether their beliefs come through through Jerusalem, through faith, or through Athens, the Athenian approach of philosophy. Both instances are examples of individuals from the depths of their being trying to understand the meaning of the world and their life. And Professor Perry quoted a number of very interesting passages to that effect. And I'm mindful of Oliver Wendell Holmes here, who wrote once, "It is revolting to have no better reason for a rule of law than that it was laid down in the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have long vanished since, and the rule simply persists from blind imitation of the past." So perhaps that gives us something to work with. If you look at the historical materials, there is actually an interesting congruence between the UN Charter's insistence that people treat each other as brothers with early acknowledgments that equal regard for citizens' conscientious beliefs, whether religious or not, treating them equally, treating them with regard, was an act of brotherhood. In a eulogy to Benjamin Franklin, a Catholic priest made just that case, actually, that it was unbrotherly to try to force people's conscience or belief systems, whether religious or not religious. During the debates about the ratification of the Constitution, the word conscience itself was invoked with some frequency. On the very last day of the Constitutional Convention in Philadelphia, September 17, 1787, Edmund Randolph, who had proposed the Virginia plan and seemed to be sort of more or less on board with the Constitution, he was the guy who proposed the thing, actually said that he was going to vote against it. And he said the reason why was, in refusing to sign the Constitution, he took a step which might be the most awful of his life, but it was dictated by his conscience, and it was not possible for him to hesitate, much less to change. Benjamin Franklin, when discussing the horrors of slavery, said that one of the greatest evils of slavery was the fact that slaves were not allowed their own sort of judgment about not only religious matters, but judgments about sort of what they ought to do, what they ought to believe, what they ought to do in their life. He wrote, "The galling chains that bind his body do also fetter his intellectual faculties and impair the social affections of his heart. Accustomed to move more like a machine by the will of a master, reflection is suspended. He has not the power of choice, and reason and conscience have but little influence over his conduct." So those are some historical grounds for suggesting that even the founders, apart from how you interpret what they wrote in the First Amendment, had a lot of the concerns that Professor Perry also has. But I have a couple of additional questions that we can discuss, and others can discuss other things as well on this normative question. First, a question that actually is posed by Charles Taylor, in a sense, is does this go far enough? Charles Taylor is concerned with, in the book that Professor Perry quotes, is concerned with the prioritization of what he calls the contemplative life. So yes, you have Jerusalem, and yes, you have Athens, these two sort of approaches that create comprehensive worldviews that are systematic and deep and profound and core. But in other of his writings, he's talked about the valorization, the prioritization of ordinary life, and how most people, most of the time, don't go about their day walking through Palo Alto thinking, what would Kant ask me to do in this particular case, or what Mill. Instead, they respond on a daily basis to ordinary sort of incitements to act in certain ways on the basis of a melange of worldviews, or not even worldviews, just sort of instincts or attitudes or recognitions of sort of basic goods. The one question is, so does this go far enough? Can we also protect those sorts of non-comprehensive or systematic or deep-going Bertrand Russell type sort of meditations on the meaning of life, but kind of lower grade, more down-to-earth, ordinary reflections on goods and what makes life valuable? The second point is a more well-trod concern, which is does this actually go too far? It's true that whether one comes to sort of a view of the world through religion and faith or through reason, we ought to give that equal regard in our daily life and treat that with respect. But when we think about what the state is competent in dealing with, I think we have a difference of opinion. When it comes to religious matters or faith matters, we often say, as Madison said, that the magistrate is not competent to make a determination about religious matters. But aren't we more inclined to say that the state has more competence to make decisions about even controversial issues with regard to, say, political morality or psychology or science or medicine? There, I think we're more willing to see the state act in a more robust way and impose, dare I say, even a certain amount of orthodoxy with regard to certain kind of claims about, say, racial justice, for instance, or other sort of matters of political first principle. And for that reason, perhaps sweeping too broadly, may cut into the state's rightful terrain in sort of legislating on the basis of those sorts of determinations. So those are some thoughts for Professor Perry. For Professor Rakove. First, I have a question that I'd like to see whether you accept the argument that has been made here that as either a matter of historical matter or a matter of sort of first principles, the religion clause, the free exercise clause in the First Amendment protects not only theistic beliefs but also comprehensive philosophical beliefs. It would seem, especially in light of your work that you pointed me to, that for Jefferson and Madison anyway, religion was sort of special in some particular way. Special perhaps in a negative way, potentially very dangerous, and therefore in greater need of being prioritized or compartmentalized and put off from the reach of the state. But in light of that specialness, how does that cut in this contemporary debate? Second point, this is less actually a response to your comments, actually, but to your work. In your account of the religious freedom for Jefferson and Madison, it seemed that you laid great stress on how they saw religion as a matter of the inner workings of the individual's mind, and for that reason, the state should be hands-off. As you quote in the Virginia Statute of Religious Freedom, Almighty God hath created the mind free, and that all attempts to fiddle with the mind were accordingly problematic. But most of the litigation, anyway, that it seems has happened under the free exercise clause of the First Amendment in the second half of the 20th century, as you referenced, has been not so much the inner workings of people's minds and what they actually think, but what they do. From the Jehovah's Witnesses to Mormons to Catholics, the fight has been over accommodations of their practices. I have a harder sense of where you're coming down on that particular question. Is employment division versus Smith, was that correctly or incorrectly decided, in other words? I think is where that generally sort of moves in the direction of. The final point I want to make, and this actually does link directly to your paper or your chapter and not to what you said today, so you don't need to sort of take a swing at this one, but I found this, the last two sentences or so in your chapter very interesting. For in the end, the basic insight on which the principle of freedom of conscience rests is the recognition that the religious beliefs of all faiths are necessarily a matter of inner opinion, and that opinion cannot be coerced or accurately measured or ascertained. Whatever the source of divine revelation or prophecy, none of us knows any more or less than anyone else about the supernatural or the spirit or the world to come. It is all a matter of opinion, as Jefferson understood, even as he worked out his own enlightened private theology. So that gets to the point that you were making about the religious freedom being radically subjectivized. And I wonder whether you think, first as a historical matter, whether it was that public agnosticism, that we just in general, human beings, can't know what the truth is with regard to religion, and therefore we need to give a tremendous amount of sort of respect to that legally. Or was it what Madison said in the Memorial Remonstrance, which is that it's just the fact that the magistrate himself is incompetent to make that decision. Is it public agnosticism in that sort of broad kind of philosophical fashion that you, I think, are gesturing towards? Or was it a more narrow claim that we may or may not actually be able to inject some reason into our reflections about faith, but as a matter of governmental policy, magistrates should be hands-off? So those are a few questions. You're welcome to take a stab at them or open it up to the audience. Thank you.
Nancy, do you want to open it up? Or you?
Yes, I mean, why don't we open it up to the audience, because we have less time.
Maybe just take a couple of minutes to say something? No, you don't want to?
For you to say something, Michael?
Well, I'm just thinking that Derek, his excellent comments made particular points. Mm-hmm. So I thought it would be clarifying for the audience to say that Derek's principal critical commentary, well, remember what I said, that a version of the right to religious and moral freedom has been introduced into the constitutional law of the United States, albeit under a different name. Mm-hmm. I then made the further claim that it would be less controversial if that had been done in the name of the right to the free exercise of religion. Derek's principal critical commentary has to do with how controversial it would be to elaborate the right to the free exercise of religion along the lines of the right to religious and moral freedom. Derek's criticism presupposes a position on the outer bounds of constitutional interpretation and adjudication that I've spent much of my career engaging those issues. I was talking to Stephen Knapp about when we met back in the 80s. That would be a distraction for those of us at this conference, so I'm not going to comment on that. So I thought I should say that.
Okay, I'll be real quick too. So Derek asked 3 questions. Would the original understanding protect other beliefs beyond religion? No, actually, of the First Amendment, no, I think not. I think they were preoccupied with religion as being a unique problem. I often try to explain this to my students to say, for us, the big surprise with the framers is they didn't care enough about race, which is what we expect and want them to have cared more about. I think one reason was they were still preoccupied by the legacy of religious persecution. Race was a novelty. Having said that, I do think Jefferson's a great example of this, that the general model, let's open it all up for debate in the religious sphere. What difference does it make if I say there's one God or 10,000? We can argue about that for a long time as long as there are no overt acts. I do think it leads towards a more general model of open political discussion, which is what I try to say. And I think that works well for Jefferson. Second point, is it about minds or practices? I think originally it was about minds. This is a point I want to kind of come back and maybe talk about with Mark. I mean, I do think that conscience in the mid to late 18th century was primarily about matters of internal belief. And that's one of the things I have to think about as I try to make more sense of exactly what does conscience mean. Now, it seems to me we have solved that problem, and now First Amendment law takes the form of a number of very particularistic claims about special practices. For example, is it the Weissman case? Can you wear a yarmulke or not if you're an Air Force? You're an Air Force officer, right? So, can you wear a yarmulke if you're I think it was an Air Force officer who was involved in that case, right? Can you wear a yarmulke or not? A whole host of practice-based things, which are very particularistic. That's what First Amendment law is now about. What I'm trying to say is the fundamental original point had this much broader canvas. So second point. Third point, the radical thing I end this essay with is that I happen to think, and this is another point we're discussing, I happen to think that, my guys, the late 18th century guys, they're all embedded in a Protestant worldview. I mean, whether they're, more enlightened or less enlightened, more like Jefferson, Madison, I think are really moving away from Christian. They're moving towards the Rakovian catechism or whatever. They're moving towards Socinianism. But they're, it's kind of like Lincoln. They're all embedded in a Protestant worldview. And so I think the idea of religiosity is first and foremost defined in terms of your interior beliefs about salvation was normally privileged for that generation. They're not living in a liturgical society. The Protestants are not deeply invested in liturgical practice, behavioral matters. Again, it comes back to what is the scope of conscience, what does it relate to? So in that sense, we are, as I like to tell my students, I don't care whether you're Jewish, Catholic, Muslim, whatever, if you come to America, we're all Protestants in terms of how we think about religiosity, how we think about engagement. Now, on the other hand, so that's this peculiar legacy. I do happen to think, so question, if it's a fundamentally Protestant belief, do American norms break down if you're dealing with a society based on Sharia or Orthodox Talmudic learning, or if we went to Mea Shearim or whatever in Jerusalem, would we expect a Jeffersonian understanding to apply? I don't think so, but I want to say all claims of religious authority are ultimately at the same level because they do involve commitment to some proposition none of us can ever prove. All rest ultimately on a belief in, I shouldn't say all, because now we'll get into Michael's world about it, but religious beliefs conventionally defined all rest upon some notion of revelation, about which we're all entitled to be equally skeptical.
Now we can open up.
Yeah.
We can open up.
Really. So I was very intrigued by the final turn in Professor Perry's paper, which, if I understood it correctly, I want to make sure that I can reconstruct that final turn in the argument and then just ask a question about it. So it was the claim that the Supreme Court would have been better off in a series of rulings on what might broadly be called privacy cases, or we might popularly understand as privacy cases, if it had resorted to the free exercise clause instead of other grounds. And if I understood the trajectory of the argument, that was derived from the previous discussion in the paper of the grounds for limiting the scope of a right, the grounds on which a government could intervene to limit the scope of a right, and those were legitimacy, least burdensome alternative, and proportionality. Most of the focus was, of course, on legitimacy in this presentation. And my understanding was that what's implicit in the way the international community has interpreted that restriction is that it can't be based on a standard derived from a sectarian belief. Is that basically the nutshell?
My articulation of that is sectarian religious or moral belief.
Yeah, so sectarian religious.
Obviously, economic beliefs can be sectarian too. But.
So I guess what I'd really like to understand is whether that's sufficient if one considers just basic notions of things like community standards. In other words, why couldn't it be the case? Take a case like masturbation that you mentioned, or more neutrally, singing in the shower, right? Something that is that a community finds repulsive for whatever reason, not because it's based on a belief, but based on, say, revulsion. And why couldn't that be grounds for a state to intervene legitimately to restrict the exercise of a right without, unless there's a guarantee of something like a right to privacy? That's what I'm really trying to get at. Just to understand more clearly why you think the Supreme Court would have been better off not invoking privacy but invoking free exercise.
That's a very interesting question, Stephen. I guess I tend to think about those revulsion-based grounds as a species of moral grounds.
Yeah, and I guess that would be that's what I'd want to probe.
Yeah, and so if that's reasonable to ultimately understand them, to assimilate them to a species of moral grounds, then I suppose what I've said in the paper is responsive to what you're asking, because you're just asking me about a different kind of sectarian moral ground. Unless you're saying, I mean, let me see if I can offer a friendly revision of the question. You can imagine a political community where a particular moral judgment is not sectarian, and a different political community where that moral judgment is in fact sectarian. And so the revised question would be, in the community where the moral belief is not sectarian, is it a violation of the right? You see where this is going, whereas in the other. I am thinking about this issue primarily, if not exclusively, and maybe so, in the context of morally and religiously pluralistic democracies. And so the real world issues that cause me to think about these issues, that is to say, the nature of the right, such as same-sex marriage, abortion, physician-assisted suicide, and I hope you won't assume you know where I'm going with respect to those issues, because I think they're very complicated. And that question, that revised question, is a real question, but it's not one that in the context of religiously and morally pluralistic liberal democracies arises with respect to the particular controversies that mainly engage me.
Yeah, I mean, I guess the question wouldn't be whether you had to have consensus in the community, but whether the will of the majority in a case like that, if it was a non-sectarian majority, moral value, belief, even at the level of revulsion,
right.
Non-sectarian but nevertheless held by the majority.
Right. I think we can answer that question by saying that we would certainly not be comfortable with government reliance on a religious belief that was endorsed by the vast majority of the people, but nonetheless, obviously, it remains sectarian. So I don't know why it should be different with respect to moral beliefs. Let me just say something here that because the issue of the contraception cases in 1965 arose in my claim that that's actually the beginning to introduce into the constitutional law of the United States something like this. Some of you may know that John Courtney Murray wrote a memo to Boston's Cardinal Cushing at about the time the Massachusetts legislature was thinking of getting rid of the anti-contraceptive law. And in the memo that Murray wrote to Cushing, he specifically said, we cannot defend this policy on contraception any longer in terms of protecting the public morals, because he says it's perfectly clear that many people of good faith, including many other religious denominations, don't share our view of this. So would it have mattered if all the Catholics, if Catholics in Massachusetts had been, if most of the citizens in Massachusetts had been Roman Catholic and moreover had been traditionalist, that is, devout believers in magisterial teaching, with respect to the issue of the whether to revoke the legislation on contraception, I don't think so. I don't think that was Murray's point. In any event, my answer to your question is that it doesn't matter whether it's a large majority that endorses the view.
So just a very, very quick rejoinder to that is that I think the concern is, sure, if the majority is voting on the basis of religion, then clearly that's at odds with the free exercise of religion of the clause of the First Amendment. The question, though, you're raising is, can you use the non-sectarian route to the free exercise of religion to prohibit the state from using a vote of a majority that's not based on religious motives, but based on moral motives?
Right.
And that's where I think there's a little bit of a loop there that needs to be worked out.
Right, and my response to that is the whole part of the paper that says, along with McClure and Taylor, that we should understand religious diversity as an aspect of moral pluralism. It makes no sense that we're managing religious diversity but not moral diversity with a right just to religious freedom. It's the right to religious and moral freedom. Now, whether that right can plausibly be defended as an aspect of the constitutional law of the United States is a separate question and involves lots of questions that would take us well beyond the jurisdiction of this conference.
Thank you.
Wyatt, the tiniest of questions. You said 85 nations signed on to the document
The
whose
ICCPR.
which names escapes me. Is there any particular characteristic of those nations that did not sign on?
I said 85%. That's
Oh, I thought
about
you said
165 out of 193 members of the United Nations. So there are about 193 potential parties to the covenant. 165 of those nations are in fact parties to the covenant. So you're asking me what characterizes those who
Well,
did
no,
not sign on?
my question's now moot because I thought
Saudi
you said
Arabia is
85.
one, for example, that did not sign on. So you can probably see where you're going with that. I don't know whether Myanmar signed on.
That's it. It was just a fact question. I'll think about it.
Go ahead.
I would like perhaps to shift to international law. The notion, let me start with this phrasing perhaps, maybe not on religion, but for instance, it always struck me how interesting that we, in the mainstream, characterize others as, or certain others, as those who are horrible enough because they kill their own, and thus we are better than they are because we do not kill our own. Yet, by us, so we sanction essentially in the international law or law of foreign policy, if there is such a thing, the killing of strangers. That becomes a totally moral, open question, far more open in the age of a nation state and the constitution of the nation state, which the United States of America has done wonders for this moment of human history to introduce. Similarly, we have states like Israel, Saudi Arabia, Iran, where you have this complicated relationship, for lack of a better word, with religion, religious freedom, and secularism and politics, and our relationships to those states. And I just want to know from you also a third point, this idea that international law is also written, there's a quote in a poem, "He who writes the story owns the meaning entire," sort of a Walter Benjamin concept. So it's the notion that modern law is written by powers that actually also modulate and influence international law. International law is quite a mess in who adheres to it in reality and who does not. And I felt in certain parts the conversation was above my head and also educational, but also I wanted to bring it back for me in this relationship, almost a schism between the domestic and the international.
I am not sure what you're asking me.
Yeah, I figured. Well, I'll leave it at that then. Okay. Oh, it's okay.
I could probably give a short answer to Fadi's question, but maybe I'll ask mine first and then go back to yours. And my question is, well, first of all, I wanted to say that I really appreciate in the panel the attempt to pull apart conscience from morality, from religion, because these things, and let's throw ethics in as well, these things are very difficult to separate out, and especially as we go forward in time. But my question is directed to Jack, and mostly I'm wondering if you know the answer to this, which I've been looking for a while. So you asked us to remember that when the Constitution was being put together, religion meant, we have to try to understand what religion meant at that time. It's not, we can't be anachronistic about it. And I'd say the same thing for conscience as well. I mean, we've seen today that we're confused about what it means. But I think the fact Derek brought up, that Madison was so concerned to get conscience into the First Amendment, and that it was in every draft except possibly the penultimate draft, it sounds like you were saying, and then it's absolutely not in the final draft. So that does seem to indicate that there was something about the way conscience was understood that made it, well, I think Michael McConnell's argument is that it was potentially a wild card, and it has proven to be a kind of wild card. And this is why you have all these cases in which you try to adjudicate secular conscience. But I'm just wondering if you have, if you have an opinion on why conscience was elided. You also used freedom of conscience and free exercise interchangeably in your address.
So promiscuously. Yeah.
Yes,
No,
you're
which- no,
promiscuous.
which is a bad idea.
Right, and so just the other thing I wanted to propose about that, and this goes to what Michael was saying about this international covenant on human rights, and that's what I was going to say, to Fadi, is that so much of that discussion was about this international covenant on human rights. But it seems to me that one way of answering the question about the elision of conscience from the First Amendment is that free exercise has to do with possibly collective action. I mean, it has to do with action, exercise. And that action would not normally be individual action. It would normally be collective action or, institutional action, for example. Whereas conscience is usually understood as a private thing, as an individual thing. In other words, was there an attempt to kind of keep it to the level of belief, but not to the level of the enactment of that belief? Could that be a possible reason?
I'm not sure Roger Williams thought about it as collective action, since he had a rather anarchically individual notion of what it meant to be a free exerciser. So, but that's just a quip. I haven't, to be honest, I haven't thought much about this. But as I listen, and it goes back to actually your introductory remark, I don't understand why free exercise itself is not a sufficiently capacious term to capture freedom of conscience.
Well,
how could you exercise religion freely without having the capacity as an individual whose rights are being protected to have come to your own judgment as to what it meant? So that's a case where I wonder, one term I think has the more limited meaning, and the second term, the free exercise term, I might argue, but I'd have to think more about this. Okay. Why doesn't it simply subsume the other? Now, with the framing of the First Amendment, I have to go back and look at the sources here. I mean, Madison had worried, as he writes to Jefferson on October 17, 1788, to name a non-random date here, that if you try to put a freedom of conscience into, or you try to protect religion generally in a Bill of Rights, you might wind up having to use narrower language than ideally you would want to have. Why? Because if you're going against the grain on behalf of individual rights, you might have to accept less than you ideally wanted. He wasn't sure that was a good idea. I mean, actually, Madison says in so many words, maybe we'd be better off without such an article. You think about his logic of Protestants, what's the best way to protect religious liberty? Turn Protestants loose to argue with each other, and they'll never have any closure in their inability to reach agreement. It's the Madisonian theory of faction.
Yes.
Will work really well. So his initial position was to wonder, given his observations of America, would you really need to protect it explicitly? Then you go forward some months, 6 months or 7 months, when you get to June, so 8 months to get to June 1789. And okay, now he does draft, A, he does include conscience, but B, he is more particularistic in the original language of the First Amendment. But of course, the funny thing that happens is when it comes out of the Senate, it's kind of a mess, no articles of faith. But leaving all kinds of establishmentarian possibilities open. Madison's in the conference committee, which actually does exactly the opposite.
Yeah.
It adopts as broad gauge in general, no law respecting establishment women prohibiting the free exercise thereof. So he goes back to a broad principle of generality for which there is an inadequate documentary record to explain how do you, if you want to really trace the legislative history, how to get from point A, B, C to the final version D. I don't know how well this answers your question. I think my big takeaway is I don't understand why free exercise does not by itself capture conscience.
Right.
Understood in the primary sense of people have to decide for themselves, consistent with Lockean principles, to which Jefferson and Madison, I think, did sign on, that the essence of religious belief is to form a notion of salvation such that God would respect the authenticity of what you were doing. That's the best I can do.
Okay. Yes, Nathan.
Hi, this question's from Michael. I don't know, can you hear me? Okay. So the question is, with respect to the results of the ICCPR's Article 18 protection in places that have been trying to bring it to bear on actual disputes. And one of the reasons I think people have given for perhaps preferring a narrower definition of the right at stake, whether it's religion or conscience, but worldview can be hard to narrow down, is the concern that the broader you make the definition, potentially the shallower the right is going to wind up being. So Justice Frankfurter, in his dissent in the flag salute case, Jehovah's Witness children chose not to salute the flag, and the Supreme Court decided that they didn't have to under the First Amendment. Frankfurter, had one of the most capacious understandings of free exercise of religion in that opinion, but he would have not given them the right to not salute the flag, because in his mind, it was freedom of thought, belief, maybe even morality too, but it wasn't a freedom of action necessarily. And the government in this case, in any case, had a really good reason to obligate children during wartime to salute the American flag. So that's just background by saying I don't know how this has been implemented abroad. Does the way it's been implemented in other countries or in the international sphere kind of put the lie to that concern? Or were they actually able to give robust protection to even non-religious conscientious rights?
I should, two responses. One, I am relatively ignorant with respect to the case law I would need to know to answer your question. But the second response is you'd have to look at multiple jurisdictions. I mean, for example, I was citing the Canadian Supreme Court. That would be one place to look. You could also look at the European Court of Human Rights, because the European Convention on Human Rights articulates the right in exactly the same terms as the International Covenant. With respect to the International Covenant, you have to look, it's not until a country has signed on to the optional protocol which then they agree to the individual cases. So look at that case law. And both with respect to the European Court of Human Rights and the Human Rights Committee under the optional protocol, so much of what's happened has happened relatively recently that they begin to take seriously this, not just this right, but a whole range of rights.
Right.
So I'm sorry, Nathan, I just don't have sufficient information to answer your question.
Okay.